one of my academic postulations, I have defined laws as contained in our statute books as inchoate, as laws that are developing, that are evolving. Those laws are given life and become full-blown laws when they have been given judicial interpretation. And judicial interpretation is can also evolve from the trial court to the appellate court to the final court of the land. And when the Supreme Court, interprets a matter that has passed through these stages of a judicial process and arrive at a final interpretation of a particular section of the law, it becomes a full-blown. That was my philosophy of what law should be from a realist, point of view. And I don't know exactly. I just stumbled into the news and how INEC declared a prison inmate, a winner of a rerun election based on the tribunal having nullified the election and ordered the rerun election. So the question is, did INEC try to conduct another rerun election and it became impracticable? And what was the circumstances under which they now have to rely on the previous result to declare the winner, the Labour Party candidate as the winner? So, but the legal issue is sacrosanct. If INEC has made a fresh declaration, that fresh declaration supposes that it is standing on the decision of the tribunal that nullified the election and has ordered INEC to conduct another rerun election. Rerun also presupposes that election has been cancelled. So it is those that were party at the previous election that will also be party candidates as the rerun election. But if it were to be a by-election, political parties will only have the opportunity to field in new candidates. So that is why it's called rerun. So at that point in time, is INEC acting based on the judgment of the tribunal that nullified the election and has ordered the rerun? And if in the course of conducting a rerun, the rerun also proved to be inconclusive, and how it now happened that they relied on the previous result, I don't have the actual fact. But what I know is that Section 66 of the Constitution is very clear as to who is qualified to be a member of the House of Representatives or a member of the Senate of the Federal Republic of Nigeria. So if this man has been convicted, not that is on awaiting trial, of course you know that somebody on awaiting trial can also be in prison custody. So, but if he has been convicted by either a magistrate court or a high court and he is on appeal at the Court of Appeal, why do the INEC has the constitutional power, or does he have the constitutional right to be declared a winner of the election? That is what I want to focus on, the constitutional implication of what INEC has done.
Okay, we'll come to that in respect of his being qualified or not.
Did INEC know that he is now in prison custody? Has any of the parties gone to serve INEC CTC of the judgment of the magistrate court or the high court that sentenced him to prison? So these are the questions to ask.